May it please the Court, Justices. I appear with my learned colleague, known in the Free State as Ms. Makakati, for the applicants in this matter.
Thank you, Mr. Snellenberg.
Thank you, Justices. Justices, the background facts in this matter I think is quite simple. The first and the second applicants were married. The first applicant lost her parents at a very young age and wanted to keep her surname. Her husband, the second applicant, pledged his support, and in order to raise their child as a family unit, pledged his support and wanted and still intends to take her surname. But they were informed by DHA that the system did not provide for that, and at a later stage that it was could not be complied with. The third and fourth applicants have a different scenario. The third applicant explains that she's an only child and she's got sentiment with regards to her maiden name. Her husband, you would have seen, is an attorney, and realizing that the default position, the historic origins of it, he pledged his support, but in this matter, the third applicant was content with hyphenating her surname by including the fourth applicant's surname, so it would be Donnelly hyphenated with Borman. Unfortunately, they met the same situation at the Department of Home Affairs when they tried to rectify this. You would have also, at page 130 of the record, have seen the email that they addressed to the Director General on advice given to them at the George branch of the Department of Home Affairs, to which no response was forthcoming. We do know why. This matter concerns Section 26(1) and 2 of the Marriage and Death Registration Act, as well as the regulations promulgated thereunder, specifically Regulation 18. We have, in the meantime, at the behest of this court, the respondents did file written submissions, and we've had the opportunity to peruse and consider those submissions. We'd just like, on that score, to just highlight the following salient issues. Firstly, it is conceded by the respondents that when we read Section 26(1)(a), (b), and (c) as they presently stand, it does not provide for a male to assume the surname of a female to whom he is married in a heterosexual marriage. It's also conceded that the practice stems from the historic development, and it's conceded that it differentiates, and if there is no legitimate government objective or purpose that is served by that, it is discriminatory and it is objectionable and it is constitutionally invalid. Reference was made to the Civil Union Act, which saw the light in 2006 and was adopted in 2010 by the respondents. Pursuant to that act, there was an amendment to the Birth and the Marriage and Death Registration Act. And what happened is that 26(1) was left unaffected, but in 26(2) the word her was simply included, so that it now reads, at the request of any person in the prescribed manner, the Director General may, if he or she is satisfied that there is good and sufficient reason as may be prescribed for that person's assumption of another surname, authorize a person to assume a surname other than his or her surname, as included in the population register. And the Director General shall include the substituted surname in the population register. That was the only amendment that saw the light after that Act was promulgated. 26, 1A, B, and C was left unscathed, as was Regulation 18(2)A, which is the regulation that funds application to this matter. It's one of the three grounds on which the Director General can exercise the discretion, and that relates to change in the marital status of the woman. That was also left unamended. So, the one point that comes through from the respondents' submissions is that a male adopting or assuming the surname of a female after marriage can no longer be considered to be objectionable in our country. We're not quite sure whether the suggestion is that there must be a reading in pursuant to the Civil Union Act. We referred the court at page 170 to the article of Professor Vos. We actually dealt with the terminology and the fact that if one attempts to read in, it becomes even more ambiguous. The state respondents did not draft the section as they would propose it should be read if there is a reading, and we respectfully submit they did not deal with the effect on Regulation 18, which reads as it reads, and this matter shows that the system that is employed at this stage by the department, there are vast and substantial matters that will have to be considered, policy matters, should this order be granted and the constitutional invalidity be confirmed. Budgetary constraints and so forth, and this would be a matter we submit more suitable to be referred to the legislature to redraft the provision. That is, and we refer, it's not in the heads, we looked at this after we received the state respondents' heads, but this court's judgment in David speaks to that. I'm open to questions, Justice.
Thank you, Mr. Snellenberg. In your written submissions, unless I misread them, I see nothing dealing with the justification analysis under Section 36(1) of the Constitution. In the affidavit, the founding affidavit for the applicants, I do see, or I have seen in paragraph 89, just one sentence. I hope I've not missed where this is dealt with, perhaps elsewhere. But there's just one very short sentence, paragraph 89, page 33, handwritten 33 of volume 1, I assume. The aforesaid provisions of the Act and regulations are not justifiable in an open and democratic society based on human dignity, equality, and freedom. And as I say, nothing at all, if I read correctly in the written submissions. Is that because justification is not necessary, or?
Just firstly, we start with Section 9 of the Constitution. Differentiation in this matter is least on sex and gender. In terms of 9.5, the unfairness is presumed, and justification would be forthcoming from the respondents. As it turns out, they have explained the coming into existence of the legislation. They have explained the, although not an oath, but in their representations, that they apparently seek a limitation that the surname must be linked by marriage. But that does not just justify the current section as it stands. So that is why the applicants did not grapple with it, but they also stated that no justification that they could conceive presented itself in this matter.
Thank you.
Thank you, Mr. Slenberg. Just very briefly, in arising out of that, you'd be aware that notwithstanding the submissions of the parties, the jurisprudence of this court would still require this court to undertake the justification
Yes.
analysis.
Of course. Of course.
I probably know what the answer will be, but can you assist us in any way in how we should undertake that analysis? Is there anything that may emerge that would suggest that there might be some basis for justification?
Justice, the answer must be resounding no, even more so after the Civil Union Act was adopted. That was, if anything, we respectfully submit the death stroke to this section as it's currently framed.
Mr. Stellenberg, in your earlier submissions, you said that that's a matter that should be referred to Parliament. I didn't hear I missed what you had said before that.
Sorry, Justice, with reference to the Dawood decision of this court, we respectfully submit the reading in becomes problematic. And this is a matter we respectfully submit, and we've requested that in the notice as well, that should be referred back to the legislature and to Parliament to consider. We know what happens in execution at the different departments of the Department of Home Affairs, at least in 2 provinces. There will be policy considerations that they would need to take into consideration. We assume budgetary considerations that they will have to take into consideration. But first and foremost, we've tried the reading in exercise, and we arrive at the same conclusion or the same place as Professor De Vos arrived. And without assistance from respondents as to how they want to go about reading that in, it is really a speculative issue. So our stance was from the start that this is probably a matter that would be best suited to be referred to the powers that be, to reevaluate in light of the different acts, and then to reframe and redraft or amend if I see fit to do so. That was the submission.
So even on, excuse me, for a temporary period, is the applicant saying there should not be a reading?
We have proposed a order that we say should prevail, Justice Strawn, in your bundle. In a notice of motion that was filed in these proceedings, and in the initial, let me just get the page 3 of that notice, you will see that we have a prayer pending and coming into force of legislation or amendments to existing legislation. We have set out how we think this should be applied and interpreted until those amendments are effective. So we have made a proposal in that regard.
Is it possible to achieve the same results as 4.11 and 4.12 and 4.13 with a reading in?
Justice, that I presume it should be. If this is workable, then yes.
Wouldn't that be the easier option for the court, if the court is with you, is to read in words or read down a section than to make a whole entire different declaration?
Yes, Justice, it will give effect to the first the departure point of departure is to keep legislation constitutional if one can. If the court is satisfied that the reading in like we've proposed it will resolve the issue, we don't have an issue with it, obviously not. And it will give clarity immediately to all the other people.
What is the difference that you see between what the applicant proposes as relief and what the respondents have suggested.
Just as we understand what they say, when you need to read in his, her, and when you do that in section 21 as it presently reads, it becomes to put it bluntly, vague and very ambiguous. We framed this specifically. I don't know whether there is probably a way to read what they say, to have it read like this. That would probably be an exercise, but we arrived at different readings when we did the exercise. Now, obviously, what we do is no measure at all, but we do understand where Professor DeVos comes to is why he said what he said with regards to the he's and her when you start doing that exercise.
I'll be on the notice of motion. The order that the applicants seek in paragraph 1.5 is not clear to me. Thereby subjecting any change to the surname of a male person after marriage to the authorization of the Director General. So we read that with the preamble that Section 26 is unconstitutional
by subjecting. I think that's a mischaracterization.
But I don't see the Act as doing that. The Act doesn't subject a male person to apply to the Director General for authorization.
If he wants to assume a different surname than he has.
Let me put my difficulty to you, Mr.
Yes.
Snellenberg. Section 26, the preamble says that a person shall not change their surname. Where they want to change their surname, they have to apply to the Director General.
Yes.
The proviso says that shall not apply when, and it's got A, B, and C. If we look at the regulations say the reason for the change of the surname must relate to a change in the marital status of a woman,
Yes.
assumption by a person of his or her father's biological surname,
Yes.
protection of a person in terms of the witness protection program. So in terms of the law as it is, a man cannot apply under that section and under
Yes.
Regulation 18 to change their surname.
Yes.
So
Yes, I understand.
so then I don't understand 1.5.
No, I understand why you have a difficulty with that. If the law doesn't allow it, then the 1.5 doesn't make sense. I understand.
Because the law doesn't allow the man to apply, so we cannot say
Yes.
that it discriminates against him to the
No, you-
extent that he must apply.
Right, Justice. Right.
Why is it necessary, if the court is with you, that Section 26 is unconstitutional, why is it necessary to declare the Regulation 18 unconstitutional? Doesn't it follow, as a matter of law, that the regulation would not be able to exist without the main provision?
Yes, but save for 18.2a, the other two provisions, the other two grounds, I don't think there's an attack on them. So they ought to survive.
So yes, it's only 18.2a, but
That is affected
Yes.
by the
declarations of unconstitutionality is in relation to acts of Parliament.
Yes, not regulations.
Yes.
Yes, so 18.2a would be ultra-virus, the Act, yes. That would be its.
There's something else I'd like you to explain. If you look at the High Court order, page 45 of volume 1. I'm sorry, I gave you.
Page 56, just.
Yes. Yes, you see, that just says prayers 1 to 6 of the notice of motion. Where do I find the full order, please, Mr. Snellenberg? The full order that was granted by the High Court.
At page 50, 56 and 57 of volume 1 and 58.
The relief that was granted, paragraph 4.2.3.
Yes,
Was that case made out in the High Court for such relief to be granted?
I would say so, Justice. The first and second applicant's case, firstly, was that they wanted the family unit. You remember the first applicant's surname was changed to that of the second applicant unlawfully.
Where in the papers do we find that?
No, it's in. I'll direct your attention to that.
This is now specifically in relation to the relief that, in respect of the child.
Yes, you will find that, Justice. Just give me an opportunity. You'll find the discussion from paragraph 17. And specifically, obviously the first few paragraphs deals with the fact that it was non-negotiable for the first applicant to retain her surname. Paragraph 23, the second applicant expressed his wish one day to assume my surname at the time of our marriage so that we can become the Jordan family and raise our children with that surname. And it was with the aforesaid intention that they went to the DHA. So, if Mr. Jordan...
Where in the papers is it dealt with that for whatever reason their child could not get that surname?
But
Which
no, but they didn't say that the child could
see,
not
my
get that
concern is, we're dealing here with section 26,
surname. Yes,
which relates to a spouse's surname.
yes.
There are different sections in that act which deals with how a child gets a surname.
You'll appreciate, Justice, that what happened is that the first applicant's surname was changed to Van der Merwe after marriage without her knowing. It's still Van der Merwe, the father is Van der Merwe, and the child was being registered as Van der Merwe. That's the consequences that followed.
Yes, I hadn't finished my question yet,
Oh, sorry.
Mr. Snellenberg. There are different sections in the Births and Registrations Act
Yes,
that deals with how a child gets their surname.
yes.
That is not in front of us. We don't know what the obstacles were for the baby to take on the surname of Jordan. Is it sufficient for the applicants to say, we want our child to take this name, therefore the court must grant that relief? When would the court be acting contrary to the provisions that deal with how you register a surname and how a child gets their surname?
If by granting this order, the court didn't act contrary to the provision.
We don't know that. That's why I asked you, in the papers, has the applicants made out a case? Have the applicants said, in terms of this section, this is how a child gets their
No,
surname?
they did not go that far, Justice. But you know what happened in practice is that the first applicant's surname was changed to Van der Merwe without her asking for it. A child could have been and would have been Jordan had it not been for that.
I don't know that if it's not in the papers, Mr. Snellenberg.
It's in terms of the Act, Justice.
But the act is also
but-
not discussed and referred to in
Yeah.
the papers.
But they all ended up being Van der Merwe at the end of the day, and this application Silverland.
What are we to do with that?
The High Court granted the order, Justice.
To go back to the notice of motion again, Mr. Snellenberg. The request is to suspend the declaration of invalidity.
It's just for 24 months.
Yes, to enable the President and Cabinet. Is the matter usually referred to the President and Cabinet or just to the legislature?
I think the legislature would have to draft it and then it would be presented in the normal course of event.
I suppose because this is a matter that doesn't affect the applicants. The proposed reading in doesn't cater for persons who are non-binary. Was that deliberate? Or
No, not at all. No, that's not. It wasn't deliberate. That's a problem with these things. And it would have been helpful if the respondent drafted the reading in. It would have been it would have served a good purpose for one to. But no, it was not.
the applicants also seek cost of two counsel.
Were
You
employed.
think this is a matter that is deserving of two counsel to be employed?
This
It's
is
a
coming-
complex matter?
Well, I've been answering questions which. Justice, if you come to a constitutional court, you take every precaution that you can think of that is reasonable. I think it was a reasonable precaution, but cost is always in the court's discretion, obviously.
Thank you, Mr. Stellenberg. Thank you, Acting Deputy Chief Justice.
Mr. Snellenberg, if we were to make or rather confirm the declaration of constitutional invalidity, suspend for, is it 24 months, and keep quiet, would that not be a judicious exercise of the discretion that we have in terms of section 172(1)(b)? Would that order not be just and be inequitable?
Justice, that would leave a lot of people in limbo for a very long period of time. Because there's really no reason why we suggested order, but take Justice Theron's point with this court's input, that the interim period cannot be governed if there is not a reading in. There's really no reason why that cannot be done. Can't see any prejudice if that is done, only benefits. But other than that, I can't take it further than that.
Thank you, Mr. Snellenberg. Those are all the questions. Thank you very much.
Thank you, Justice.
Judgment is reserved. Court adjourned.
Thank you, Justice.
Please rise.